Welcome to the deep dive. Our mission is to take these really complex, often, dense sources, in this case, a massive federal court filing, and just pull out the crucial things you need to know.
Exactly. We're going to walk you through the timeline, the pretty staggering numbers, and the specific legal tool being used here.
So today we are digging into a lawsuit about the Paycheck Protection Program, or PPP. The whole discussion is based on one source, a complaint filed in the U.S. District Court for the Southern District of New York.
Right. And it's a False Claims Act case against a prominent personal injury law firm, Liakas Law.
Okay, so let's set the stage. We have this huge government program, PPP, designed for emergency relief, and then we have a federal complaint saying a very successful company took advantage of it.
That's the core of it.
Before we get into the details of the firm's finances, can you just remind us what the whole point of the PPP was? What was the goal back in March 2020?
The goal was, it was pure urgency. The economy was falling off a cliff, and the idea was to help small businesses survive that initial shock.
So it was really about payroll.
Primarily, yes. The PPP was established under the CARES Act to give this needed capital boost so businesses wouldn't have to lay everyone off. But the key thing to remember is that speed was everything, which meant the whole system was built on trust.
And when you build on trust, you skip a lot of the usual government checks and balances.
You do.
Which brings us to the absolute heart of this legal action. The one promise every single borrower had to make to get that money.
It's the core certification.
Yeah.
And it's a specific sentence. They had to certify in good faith that current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant.
Economic uncertainty makes this loan request necessary. Let's just sit with that for a second. That's the whole game right there. It's not just about what you did with the money later.
No, it's about needing it in the first place.
And the penalties for getting that wrong they're not small.
Oh, they're huge. Knowingly making a false statement to the federal government to get a loan like this could mean, massive fines up to $1 million and even potential prison time. These are serious federal statutes.
So we're talking about fraud, not just, a misunderstanding. But this lawsuit isn't coming from the FBI, not at first. It's brought under the Federal False Claims Act. How does that work? It's a really old law, right?
It is. It dates all the way back to the Civil War.
Yeah.
It's the government's #1 tool against fraud, but the genius of it is this thing called a quit tam provision.
Quit tam.
It basically allows a private citizen, or in this case a company, to act as a whistleblower, or what they call a relator.
So an outsider is bringing a case on behalf of the government.
Exactly. The relator here is Tradesman Program Managers, LLC. They file the lawsuit in the name of the United States. Think about it. The government can't possibly audit every single PPP loan.
Not with trillions of dollars going out the door that fast.
No way. So the FCA kind of deputizes citizens to be the watchdogs. And if they win and the government recovers money, the realtor gets a cut. It's a powerful incentive.
That makes a lot of sense. So it's a built-in enforcement mechanism for a program that was designed to be vulnerable.
That's a good way to put it.
Yeah.
And there's one more piece to this puzzle before we get to the numbers. The safe harbor.
The safe harbor, right?
Right.
This was a way out.
Yes. The SBA, the Small Business Administration, knew there was chaos in those early days. So they created this temporary window. If you applied for a loan and then realized, wait, our business is actually fine, we have enough cash, you could give the money back. No harm, no foul.
A chance to correct an honest mistake.
Precisely.
Right.
The final deadline was extended to May 18th, 2020.
Yeah.
And the complaint makes a very big deal of this. It specifically alleges that Liakas Law had plenty of cash and did not use that safe harbor.
So that honest mistake defense is sort of off the table from the start.
According to the complaint, yes.
Yeah.
It suggests they knew what they were doing.
Okay, so that really sets the stage. We have the law, the high stakes, and a mischance to make things right. Now let's get into the timeline laid out in the complaint against the firm Liakas Law and its principals, Dean, Stephen, and Nicholas Liakas.
And this is where the alleged contradiction just becomes stark. The firm is a personal injury practice in New York. They work on contingency, which means they get paid a percentage of big settlements.
Big paydays. And the complaint has the numbers for right before they applied for their first PPP loan in April 2020. What did their claim of economic uncertainty look like on paper?
Well, the numbers are pretty jaw-dropping. In the 10 months leading up to that first PPP application, the firm obtained over $18.95 million in settlements.
Wait, say that again. 18?
Over $18.95 million.
In less than a year. Okay, that is not a small business on the brink of collapse. That's an incredibly successful operation.
I mean, that's the core of the realtor's argument. The complaint even lists some of the wins to drive the point home. A $2 million settlement here, $3 million there, another $3.5 million settlement in January 2020, just before the pandemic hit.
So they were sitting on or had access to a huge amount of cash that directly contradicts that certification of necessity.
That is the allegation.
And despite all that, they still got not one, but two PPP loans.
Correct. The first draw was approved May 1st, 2020 for $528,977. That loan was later completely forgiven.
And that date, May 1st, is key because they still had over 2 weeks to use that safe harbor provision and give the money back.
Precisely. But they allegedly didn't. Then, around January 2021, they applied for a second draw.
For how much?
For another $559,666. That loan was also completely forgiven.
So all told, taxpayers forgave just over $1 million, $1,099,460 to be exact, based on two separate claims of need that the realtor says were, well, just not true.
Right. And if you're claiming you need taxpayer money just to survive, the logical question is, okay, so where did it go?
And this is where the story takes another turn, right? Into what the principals were allegedly doing with their money right after that first certification.
This is what you might call the aha moment of the complaint. Just 4 months after certifying they needed help because of economic uncertainty in September 2020, defendant Dean Liakas allegedly bought a house for $1.95 million.
A nearly $2 million house.
Yes.
The contrast is just, wow. 1 minute you're telling the government your business might collapse, the next you're buying a mansion.
And the complaint uses that timing to argue the PPP funds were effectively subsidizing personal wealth, not saving jobs. And it didn't stop there. 7 months after that first loan in December 2020, Nicholas Liakas allegedly bought a house for $990,000.
So the complaint presents these purchases as evidence that the firm's own capital was more than enough to cover its costs.
That's the clear implication, that the PPP money wasn't necessary at all.
And what about the business itself? Did it slow down between the two loans?
Quite the opposite. The complaint alleges that between the first and second PPP loans, the firm brought in an additional $4,050,000 in settlements.
So they were thriving.
Thriving during the exact period they claimed was defined by uncertainty. And it gets even more incredible after the second loan was forgiven.
Let me guess, their success continued.
It exploded. The complaint says they went on to collect fees on an additional $23,125,000 in settlements. And by August 2022, they were publicly announcing a major expansion of their headquarters on Wall Street.
On Wall Street. So the picture being painted is one of a company that was doing better than ever, allegedly while using over $1 million in taxpayer money.
That's the picture. And there's one more detail about another company they started, Jumpstart Funding, LLC.
What's that?
It's a litigation finance company. Basically, they advance cash to personal injury plaintiffs, often at very high interest rates. The complaint alleges that just 3 months after getting that first PPP loan, the firm had enough extra cash to start and fund this entirely new, cash-intensive business.
So while they're taking government money to supposedly keep the lights on, they're also launching a high-interest loan company on the side.
Allegedly.
Yeah.
It just adds another layer to the argument that they were never in any real financial trouble.
Okay, let's talk consequences. What is the relator actually asking for in court?
The legal claim is a violation of the False Claims Act. The argument is simple. The firm knowingly lied on the necessity certification, and the government relied on that lie when it forgave the debt.
And because the government lost money, the False Claims Act has that multiplier effect, the treble damages.
Yes, this is where the numbers get really serious. The direct damage to the U.S. government was the forgiven amount, the $1,099,460. The FCA says you take that damage and you triple it.
So we're already at more than $3 million.
That's right. The judgment requested is for not less than $3,298,380.
Yep.
On top of that, you have civil penalties for each false claim submitted, which can range from about $14,000 to nearly $28,000 per violation. Those add up fast.
And what about the principals themselves, the three brothers? Is the law firm the only one on the hook?
The complaint specifically tries to hold them personally liable. It asks the court to pierce the corporate veil.
Okay, what does that mean in plain English for us?
It means the realtor is arguing that the corporation, Liakas Law, wasn't a real separate entity here. They're claiming it was just being used as a personal piggy bank, an alter ego, for the principals to commit this alleged fraud.
Especially with the house purchases.
Exactly. If the court agrees, the principals would lose the legal protection of their company and their personal assets, houses, bank accounts, everything could be used to pay back those damages.
That raises the stakes to a whole other level. So as we wrap up, what is the single biggest takeaway from this deep dive?
I think the biggest takeaway is just how this case perfectly illustrates the collision between emergency relief and fraud enforcement. It all comes down to the stark contradiction between that required statement of need and the overwhelming documented evidence of the firm's massive ongoing financial success.
The numbers in the complaint just don't seem to line up with the words in the certification.
They don't. And that leads to the final thought we want you to really consider. The PPP program had to rely on trust and good faith because the crisis demanded speed. But that reliance created this huge vulnerability.
Right.
So what does this case really tell us about that constant tension the government faces? That pull between getting life-saving aid out the door immediately and ensuring the long-term integrity of taxpayer money. The system for catching this alleged fraud wasn't a government audit. It was this Civil War-era law that relies on citizens to be the watchdogs.
That fundamental tension between speed and integrity, that's a fascinating point to think about.
It's really what the legacy of the CARES Act will be all about.
Well, if you needed to understand the mechanics of federal fraud, the power of the False Claims Act, and the startling allegations against Liakas law, you now have the essentials.
You're well informed.
We'll catch you on the next deep dive.